Welcome to the Justice Room. Your life, your rights, your options. Experience and learn from discussions with legal professionals and other experts about the law, its challenges, and how it could affect you. Here at the Justice Room. Welcome to the Justice Room.
Explain a little bit about why it's important for the people to get a withhold if they come across this situation, if they find themselves here. Why is it important that they do not wait until they have an HTO file?
Because language is very important in law, and the statutes are written in such a way that Tallahassee is using one certain word to use these civil citations to operate as one of the three strikes that would habitualize someone.
Would you know what that word is at Tallahassee?
Conviction.
Conviction, okay.
Okay, you have to have three or more convictions.
Now, what would constitute a conviction? That means that you've paid the ticket.
And you were adjudicated, and we talked about that word before. You were adjudicated guilty, which means that you were formally convicted of that civil citation. A withhold of adjudication means that you were not convicted of that civil citation. Therefore, the word convicted can't be used against you to operate as one of those three strikes that would serve to habitualize you under the Florida statutes.
I have a question then. Let's say that your driving while license suspended, you pay the ticket, and you get the withhold.
Yes.
Can you do that every time?
You can do it once every 12 months. The statute says if you have not elected this option within the past 12 months, then you're entitled to it. Mm-hmm. If you got three all in 12 months, no. Under the statute, you wouldn't be entitled to a withhold. Now, you could still go to court and ask for it, and some judges might give it to you. But we're talking about entitlements here. The statute specifically entitles the citizens of this state to a withhold of adjudication if they pay their ticket, take care of whatever fines, whatever was causing their driver's license to be suspended in the first place, take care of that, show proof of compliance to the clerk of court, and ask for your withhold. If you haven't done that within the past 12 months, under the law, you're entitled to it.
Now, in this law, I've also found, and we talked about this before the show a little bit, a DUI can affect your driving while license suspended. Or sometimes you even get arrested for a DUI, and it's almost, this is a whole nother topic, but you can have a driver's license suspended on the first offense. It could happen.
A DUI, under the law, there are no withholds of adjudications for DUI. So if you're convicted of a DUI, a withhold is not an option. So now, again, there's that word convicted again. You've been convicted of an offense that will operate as one of those three strikes. So if you have a DUI and then a driving with license suspended, and then you get the third driving with license suspended, and you're adjudicated guilty, in other words, convicted of all three of those offenses within 5 years, Tallahassee will suspend your driver's license or revoke your driver's license for a period of 5 years.
Okay. So then somebody could easily have a DUI that could still be ongoing, but let's just say it's still within the criminal system, if you will. And then they get a ticket, or they're driving while license suspended, don't know it. That's two strikes in, let's say, 2 months. The DUI automatically does not qualify them for a non-conviction, is what you're saying.
Right, but what you're asking me is if the DUI has not been resolved, and that would not operate as a strike because, again, that word convicted, you have to have three convictions of any one of these offenses that would operate as a strike. So if the DUI has not been resolved yet, it would not operate as one of those three strikes.
Okay.
Once you enter a plea of no contest or guilty or found guilty at trial, then you would, by law, have to be adjudicated guilty of the DUI, and as soon as that happened, it would operate as one of those strikes.
Okay, are there any other strikes? Because we talked about this a little bit. We talked about how, and I think the people need to understand this, driving while license suspended is there's two different types that can happen. You have driving while license suspended with knowledge and driving while license suspended without knowledge. Now, let's try to explain a little bit about what the differences are between with knowledge and without knowledge, and how can that happen?
Well, we've been talking about Willis's without knowledge, which is a civil citation. We've talked about how an adjudication to that offense can operate as one of the three strikes. What can also operate as one of the three strikes is a criminal dwellis, criminal driving with license suspended. It's under the same statute, but it says that you were driving with your license suspended with knowledge. You knew your license was suspended and you drove it anyway. There are several different ways that they can prove that. If it was a point suspension, if it was what we call a not curable suspension. In other words, there's nothing you could have done to have gotten your license back, and you drove on it anyway. It's very easy to prove up a driving with license suspended with knowledge. And the first time that happens to you, it's a second-degree misdemeanor. Second time, it's a first-degree misdemeanor. Third and subsequent times, it can be charged as a third-degree felony. Now, the other way they can prove knowledge is if you were driving with your license suspended and the law enforcement officer comes up, did you know that your license was suspended? And you say, yes, sir, I did, but, and try to explain why.
Right.
That's an admission that's admissible in a court, and they can prove it up that way. But if you paid a ticket late, or the toll violation example you used, and you didn't know that just because you paid your ticket late, they were going to suspend your license, and not only did you have to pay your ticket, but you have to go down to DMV and reinstate your license. Now your license is suspended. You don't realize that. You get pulled over because maybe you haven't done anything wrong, but the law enforcement officer's behind you and he's running your tag through what we call David, their computer system, and it says, oh, this guy's driver's license is suspended, pulls you over. Did you know your license was suspended? No, sir, I did not know that my license was suspended, and it was suspended for a monetary reason. You paid a ticket late. Then they cannot prove knowledge, and then he would have to lawfully only give you a civil citation.
But now, when you say lawfully a civil citation, you could possibly be arrested for driving while your license is suspended.
Absolutely, if you admit to knowledge, or if they think that you did know that your license was suspended, then they can arrest you and prosecute you criminally.
Now if it's a civil citation, can they still arrest you for that?
No, that's the difference between criminal and civil. Civil is just what it is. It's civil, and you can just pay a ticket. It doesn't require a court date, but criminal is completely different. Now, there is one other distinction with the criminal driving with license suspended or revoked that is important to know. It does not matter if you get your adjudication withheld on a criminal dwellis. It still operates as one of the three strikes against you. So if you're charged with a criminal dwellis and you ask the judge for a withhold and he gives it to you, you haven't really done anything with respect to the habitual traffic offender ramifications that are possible.
Okay, so wait. So what you're saying then is that if I get pulled over on a driving while license suspended with knowledge, so I knew about it, and I go to court and I ask for an adjudication withhold and I ask them to grant that, and they grant this for me. Now, as my example, what I'm trying to say is, a year from now, I get again a dwellis without knowledge. And then a year